On Law Weekly today, we look at the legal implications of the court order freezing accounts without BVN. We talk to two senior lawyers. Also on the program today, we look at the issues surrounding the reinstatement and subsequent sacking of the former chairman, Presidential Task Force on Pension Reforms, Mr. Abdulrasheed Maina, plus our recap of the top trending stories from the courts. Hello and welcome to the program. I am Shola Shuyeli. Last week, the news broke that a federal high court sitting in Abuja had ordered the forfeiture of funds in accounts without the biometric verification number BVN. These has predictably generated a lot of outcry, with most people debating the implications of such an order. To deepen the discussions in the public sphere, Law Weekly spoke to two senior lawyers on the legal implications of the order.
The order obtained by the Attorney General raises a lot of legal issues, and one that I think needs to be well considered. It'll be interesting to see what the defendants will do in the action, which is all the banks in the country. So we all know that the Attorney General approached the courts for an ex parte order against all the banks. I think the first thing is that I think it violates a fundamental principle laid down by the courts, that lawyers should not approach the court for ex parte orders except there is a situation of impossibility, an emergency that cannot be met in the day. All the banks, there are just 20 odd banks in the country. They all have offices in Abuja, or they're all headquartered in Lagos. And the Attorney General could reach any one of those banks. None of the banks were running away. So first of all, I don't know why they had to go for an ex parte order. So I think that's the first thing that I think was wrong with the Attorney General did. As the chief law officer in the country and number one person, in the legal profession, I think he ought to know that it's really an abuse of process. Now, because he's Attorney General, tradition is that the courts would give him a lot of respect and deference. And therefore, I'm not surprised that, the trial judge bent over backwards and granted the ex parte order. But having said so, I think there's so many things wrong with the ex parte order. So, BVN is something that has come out of a circular or a number of circulars issued by the central bank, the latest being one which was issued on the 18th of October, so just a few days ago. I think this started in 2014 when CBN, quoting sections 57 of BOFIA, section 2D of the CBN Act and section 47(2) of the CBN Act, issued the guidelines on BVN. And it said there clearly that it had consulted with all the deposit money banks. And the essence of issuing the circular and engaging in BVN was one, to enhance electronic banking settlement and also to improve on banking settlements, and so on and so forth. And lastly, to aid in knowing your customer, which is an international convention that we all do. So the latest circular issued by the central bank, as I said, on the 18th, also then has a framework, a regulatory framework around BVNs. And what does it strike at? It says two things. Number one is addressed to the banks and banking customers. It requires all the banks to know their customers. Brings in NIBS, which is a clearing system for all the banks, and expects NIBS to be the central depository of all the data. The sting in it is that it seeks to deal with fraud and says that there must be a special database of any banking customer that's been found guilty or engaged in fraud. And what it says is that when that happens, the penalty is you restrict activities of the customer or you close their account. It doesn't say you can take the money, because central bank cannot take anybody's money. And no one in the country can take anybody's money other than through a court order. So the central bank framework is fine, does what central bank says it can do. So you then ask yourself, so on what basis was this done? So it clearly could not have been done on the basis of CBN circular, which is subsidiary legislation. We have the Money Laundering Prohibition Act, and that provides, I believe in section 2, for banks to ensure that they know their customers well, which is a good thing. And then provides in section 16F that if any bank does not comply with the law on knowing the customer, the bank or banker will be tried and convicted for operating an account that doesn't comply with KYC rules. So again, you will see that even in the principal legislation around knowing your customer, there's nothing like forfeiture. So I begin to grasp for straws in the ocean where the Attorney General has thrown us into how he came about thinking he could get this order. Because I just can't begin to situate it in any law.